Chapter 12. Rights analogous to those of trademarks. Section 521. There are two species of property which are protected by courts, on principles analogous to those on which rest the decisions in cases of trademarks proper. These are the goodwill of a trade, so far as it is contained in the style or title of a partnership, or the name of a trader, or the description of his place of business, or peculiar manufacture or product, and labels and wrappers of goods, and property in a name or distinguishing style, as connected with a literary publication, or a work of art. There is another class of cases, too, which must not be entirely omitted from consideration, those in which the interference of a court has been grounded on the general doctrine of the prevention of damage arising from a breach of trust, or confidence. By this method of classification, many cases may be considered under one general head. Section 522, Goodwill. The authorities in general describe the goodwill of a trade as a probability that the old customers will resort to the old place. Judge Story says that it may be described to be the advantage or benefit which is acquired by an establishment, beyond the mere value of the capital, stock, funds, or property employed therein, in consequence of the general public patronage and encouragement which it receives from constant or habitual customers, on account of its local position, or common celebrity, or reputation for skill or affluence, or punctuality, or from other accidental circumstances or necessities, or even from ancient partialities or prejudices. Thus, a nursery of trees and shrubs, a favorite fashionable stand, or a newspaper establishment, may and often does enjoy a reputation and command a price beyond the intrinsic value of the property invested therein from the custom which it has obtained and secured for a long time, and this is commonly called the goodwill of an establishment. Section 523. The extent to which a goodwill is protected is fully illustrated in Goodwill v. Lye, as is also its nature. In that case, the goodwill consisted in certain premises in Bath and in Bristol, which were sold by the assignees in bankruptcy of one of the defendants, Edward Lye, who had, for some years, together with his father, George Lye, carried on the business of a carrier from Bristol through Bath to London, the same parties having also a carrying business from Bristol through Salisbury and Warminster to London. At the sale, the whole of the premises of the Messrs. Lye, and their business as carriers from Bristol through Bath to London, and the goodwill of that business, was sold in one lot to the plaintiffs, the carrying business from Bristol through Warminster and Salisbury being put up for sale separately, and eventually bought by friends of E. Lye, the defendant, who then set him up in that business. The question was, whether the defendant, according to the facts stated, was really carrying on his own trade, and not that of the plaintiff. A person having sold a house and stock in trade is, in the absence of any special covenant, at liberty to set up a similar business the very next door to his former shop or warehouse. That is merely a fair case of competition in trade, but he must not, under colour of chalking out a different course of trading, really carry on, for his own benefit, the trade of others. Lord Eldon considered that the facts in that case were not sufficient to prove a fraudulent design on the part of the defendant. He said that they amount to no more than that the defendant asserts a right to set up this trade, the carrying business, and has set it up as the like, but not the same trade with that sold, taking only those means that he had a right to take to improve it. Section 524. In Peterson v. Humphrey, it was held that an injunction will lie, at the suit of one against his former co-partner, restraining the continuance of the use of the signs containing the old firm name, without sufficient alterations or additions to give distinct notice of a change in the firm. The parties were in business on Broadway, in the city of New York, and failed. Some arrangements were made with their creditors, by which they were enabled to enter into a new business, which each did on his own account, Humphrey at the former store in Broadway, and Peterson in Canal Street. Before the failure, there was a broad sign above the second story of the store on Broadway, in the name of the firm, Peterson and Humphrey, and another over the entrance door. Peterson requested Humphrey to remove those signs, and receiving a refusal, obtained an injunction to prevent the use of them. Before that, the sign on the door had above it the name of the old firm, and the word formerly, so as to read Humphrey and Co., formerly Peterson and Humphrey. The court said that this last sign was true, and nobody could be deceived by the last words, but the sign above the door might mislead, and the injunction against it should be sustained. In Howe v. Searing, the plaintiff, a baker by trade, sought to restrain the defendant from designating the bakery establishment kept by him at number 432 Broadway, in the city of New York, as Howe's Bakery, and from otherwise using the name of Howe in the business, so as to induce the public to believe that the business carried on at 432 Broadway was conducted by the plaintiff. Upon the trial at special term, it was proved that, 8 years before, the plaintiff carried on a large and lucrative business at 432 Broadway, and during all the time he carried on the business the premises had been known as Howe's Bakery, and had gained great celebrity by that name. Howe then sold out his lease of the premises, and all the stock, wagons, and fixtures used by him in the business, together with the goodwill of the concern. After the sale of the business stand and goodwill, Howe, by agreement with his vendee, obtained the privilege of resuming the business at another stand, covenanting not in any manner to interfere with the business carried on at the former stand, known as Howe's Bakery. Held, that this was no recognition of the vendee's claim to use the name of Howe. On appeal from the judgment in plaintiff's favor, the decision was affirmed by a majority of the court. Hoffman, J., said that the case was decided upon all the authorities found bearing upon it. But it is to be noticed that, under a statute of the state of New York, passed April 29, 1833, to prevent persons from transacting business under fictitious names, no person has power to transact business in the name of a person not interested in his firm, and that act would have been sufficient to warrant the decision made by a statute passed April 17, 1854. A co-partnership name may be continued by some or any of the co-partners, their assignees or appointees, upon filing and publishing a certificate, but that provision applies only to firms having business relations with foreign countries. The court, independent of any regard to the statute, recognized the principle, as one of public policy, that business must be transacted under the name of the real parties doing it, and not under other names. Section 525. This decision fully accords with the law of France in relation to commercial partnerships. By the 21st article of the Code of Commerce, the name of the associates can alone constitute the firm name, la raison sociale. This is intended to forbid persons who succeed to the business of a deceased merchant from continuing it under his name. Credit, said Hoffman, J., in commenting upon said article, is altogether personal. It does not transmit itself by cession or inheritance. It is won by actions and capacity. It is not right, then, that a successor should avail himself of a fallacious credit in appropriating a firm's name extinguished by the death of one of those who gave it the value. Section 526. It has been a question whether the right to use the firm name is a part of the goodwill belonging to the partnership, or whether, in case of the dissolution thereof by the death of the partner, it belongs to the survivors. That the right to use the name of a known and celebrated firm in the case of manufactures is often a very valuable possession, is unquestionable, and, therefore, courts of equity will often interpose to protect the right against the abuse of third persons, in using it for their own advantage. But it has been thought that this right does not fall within the true character and nature of goodwill, but that it belongs to the surviving partner. The case of Lewis v. Langdon 3 illustrates the notion of property in a partnership name, as a species of goodwill attached, not to the place of business, but to the name of a firm, or of a trader. In this case, Vice-Chancellor Shadwell held that a surviving partner had, on the death of his co-partner, a right to carry on the business under the designation of the original firm, for that the goodwill arising from the use of a particular designation was, during the partnership, the joint property of the firm, and became on the death of one of the partners the sole property of the survivor. He, however, while granting the injunction, directed the plaintiff to bring his action at law. But this opinion does not seem to have been generally acquiesced in. Hoffman, J., in rendering the decision of the court in Howe v. Searing, intimates that it is a well-settled rule that the goodwill of a partnership business does not survive to a continuing partner, and that it belongs to the firm as much as the ordinary stock in trade. He said that the case of Lewis v. Langdon, which seems to assert a different rule, is not the law of the court on this point. He referred to the decision in Hammond v. Douglas, which explicitly asserts a different doctrine, speaking of the goodwill generally, and decides that a sale of it cannot be compelled by the representatives of the deceased partner, and that it is not partnership stock of which the executor may compel a division, but belongs of right to the survivor. But in the case of Doherty v. Van Nostrand, before him as Assistant Vice-Chancellor, he had thought that case could not be supported, and the opinion in the last mentioned case had been acted on and approved in other cases. Perhaps, says Lloyd, Churton v. Douglas approaches more nearly than any other of the numerous cases on goodwill to the case of a trademark. There, the defendant had, in 1857, received a considerable sum from the plaintiff, upon a dissolution of partnership, for the purchase of all his known rights and interests in the partnership business and the goodwill thereof. The plaintiffs carried on the old business under the name of their new firm, late John Douglas and Company. 4 months afterwards, the defendant again set up his old business, in partnership with other persons, under the firm of John Douglas and Company. The whole question, as in Crutwell v. Lye, before referred to, was whether, upon all the circumstances, this was an attempt to set up, not a business similar to the old one, but the identical business, and the court coming to the conclusion that such was the defendant's intention, granted an injunction, although the defendant's name was John, and the style was genuine. In Howe v. Searing, Moncrief, J., took the ground, in his dissenting opinion, that the words Howe's Bakery were nothing but a trademark, and as such passed by the assignment and transfer of the goodwill, and, if not the thing itself, it was an integral part of it. He was unquestionably in error in the use of the term trademark, and in his conclusion of law he is without the support of authorities. Section 527. In the Tribunal of Commerce of Paris, in 1857, Bourtain v. Merkeln, it appeared that Bourtain and wife had sold to Merkeln and wife their establishment as opticians. Among other conditions, it had been stipulated that the defendants, as successors, might avail themselves of the name of Bourtain as found convenient, but the Bourtains reserved the right to continue to carry on another place of business which they had established in another street from that of their former place. The defendants used as a commercial designation the formula, Maison Bourtain, Bourtain Opticien, without the addition of the words Merkeln, successor, whereupon the plaintiffs brought suit for damages for violation of contract in making a false representation. It was held, in the first instance, that the defendants had obtained the right to use the name of Bourtain on their signs, cards, and the case was dismissed, plaintiffs to pay the costs. The plaintiffs appealed. The judgment below was reversed, on the ground that it was only in the quality of successors in business that the respondents had the right to use the name of Bourtain, but as no appreciable injury had resulted to the appellants, no damages were allowed. To suppress the evil for the future, the court forbid the respondents Merkeln to inscribe the name of Bourtain on their invoices, addresses, and signs, otherwise than as successors of the said Bourtain and Annales de la Prop, Tome 3. p. 207. Wife, that quality to be expressly mentioned in conjunction with the name of Merkeln. The respondents were adjudged to pay the costs of the trial and the appeal. In the Tribunal of Commerce of Marseille, in 1861, Laurens v. Lorenzel, it appeared that the plaintiff, Gustave Laurens, had, ever since 1836, carried on the pharmacy founded by his uncle, Joseph Laurens, in 1814, with this sign, Pharmacie Laurens. The plaintiff signed his name as G. Laurens, and so was generally known. His cousin, the defendant, Paul Gustave Laurens, established a pharmacy in the vicinity of that of the plaintiff, and had for his sign G. Laurens. The court ordered that the defendant should qualify his designation, suppressing the name of Gustave. In the Court of Dix, in 1865, Caminade F. Company v. Caminade, it was held, that although in case of similarity in the names of two merchants, in the same line of business, the later comer is not obliged to suppress the name of his firm on his marks and labels, nevertheless he can be adjudged as an instance of good faith to add his distinctive designation. The defendant had announced in circulars that he had founded at Cognac a mercantile house, under the name of Ad Caminade, for the purchase and sale of cognac brandies. It was shown by him that, in his correspondence with his agents, he had notified them not to confound his house, just commenced, and the ancient house of Caminade, with which he had no connection, of either kinship or interest. Good faith was shown. The court held that every person has a perfect right to use his patronymic, in commerce as in anything else, subject, however, to the condition of being distinguished as much as possible from any other in the same trade. It was ordered, that the defendant's full name appear, thus, Adrian Caminade. This was affirmed on appeal, the defendant spontaneously agreeing to add to his labels, and c. the words Maison Fondée in 1864, so as to prevent any possible confusion. So, also, in the Tribunal of Commerce of the Seine, in 1857, case of Pinard Ephemour, Pina, where the names, although differently spelled, were idem sonans. It appeared that the plaintiffs had carried on a hat store, founded 25 years before at number 87 Richelieu Street, in Paris, by just Pinard, and that the defendant quitted another street formerly occupied by him, and established a hat store at number 91 Richelieu Street. It was charged that he did this to profit by the similitude of name to draw away the custom of the plaintiffs. The defendant contended that he had a perfect right to remove into the street mentioned, and that the difference in the spelling of the two names was quite sufficient to avoid confusion, and, as a subsidiary precaution, he offered to prefix his baptismal name of René Picard : whereas Pinard and Amour are proprietors of a hat establishment in Paris, in Richelieu Street, 87, and known for 25 years under the name of Maison Pinard, and whereas Pina, a hatter previously of the street Fosses Montmartre, has recently established himself at number 91 of the aforesaid street, and, with the intention of profiting by the similarity of names, he has placed over his store Maison Pina, and whereas he employs for the lining of his hats an escutcheon which is a servile imitation of that adopted by Pinard and Amour, all of which has been done to divert to himself the custom of the old house of Pinard. Now, although he has an incontestable right to establish himself under his true name, and to place that name upon his place of business, yet he must be interdicted from unlawful competition, and measures must be taken to prevent confusion in the mind of the public between the two houses. Ordered, that the defendant suppress the word maison, which in the usages of commerce indicate an establishment of ancient date and reputation. Also, that he change the escutcheons chosen by him and placed on the lining of his hats, and, finally, that the name of Pina shall be preceded by the praenomen René, and that these two names shall be placed over both fronts of his store, and on his invoices and letters of commerce, on the same line, and in the same characters. This judgment was to be inserted in two newspapers selected by the plaintiffs, the defendant to pay costs of advertisement and suit. The defendant accepted the condemnation, but he executed it in a tardy manner, and in a way indicative of bad faith. He placed his name, René Pina, on his principal sign, but on the glass of his entrance door he left the sole name of Pina. Besides that, his shop having two fronts, the one on Richelieu Street and the other on St. Mark Street, he had placed his surname on one street, and his baptismal name on the other, so that passengers on Richelieu Street, who were more numerous than those on St. Mark Street, would see but the name of Pina. He was again brought into court for his reprehensible subterfuge in attempting to continue his unfair competition to the damage of the plaintiffs. He was condemned to pay them 2,000 francs, and the costs. In the same court, in 1858, case of Bonnet et al. V. Henry Delisle, it appeared that the sign of the Maison Delisle belonged for a long time to a house of commerce, to which name the founders and their successors the plaintiffs attached a very great importance. The defendant, whose place of business was not in the same street with that of the plaintiffs, used the same designation of Maison Delisle, without anything to distinguish his establishment from that of the plaintiffs. Ordered, that for the future the defendant cease to designate his place of business under the simple denomination of Maison Delisle, and that he pay the costs. And in the same court, in 1857, case of Schwitt v. Limason, it was held that when members of the same family, or merchants bearing the same name, have created rival establishments, The proprietor of the most ancient has the right to preserve the qualification of maison, or ancien maison, and in case of possible confusion, the junior should be compelled to add his quality of successor on his signs and prospectuses. In the Court of Paris, in 1858, case of Trademarks v. Bornhonet, it was held that the successor, however far removed, of a house of commerce, has a right to put on his bills and signs the name under which his house was founded. Section 528. Courts of equity will protect a party in the use of a sign of an inn, hotel, or other place of business, where the sign or the name is simulated so as to deceive, or be calculated to deceive customers. The adjudged cases proceed solely on the ground of a valuable interest acquired in the goodwill of the trade or business. At the foundation of the principle is the idea of falsehood. If a man create a reputation for his business, it is as the keeper of some particular house at a known location, and it is piracy to draw off the custom of his friends or customers who have identified him with the name of his house. It is a personal right. By giving a particular name to a building, as a sign of the hotel business, a tenant does not thereby make the name a fixture to the building, and the property of the landlord upon the expiration of the lease, as was decided by the Supreme Court of California, in Woodward v. Lazar. One may consent to the employment of his name to designate a place of refreshment, but if such consent be purely gratuitous, or unless there is some valid agreement binding upon the party who gives his consent, he may withdraw it at pleasure, and its further use will be enjoined, as in McCardell v. Beck. And a court of equity will protect by injunction the name of an enterprise undertaken for the amusement of the public, as in Christie v. Murphy. Even although one's place be designated by two names indiscriminately, a colorable imitation of the title will be enjoined. Section 529. In France this protection is frequently granted. In the Tribunal of Commerce of the Seine, in 1857, case of Dorvault v. Purox, the plaintiffs had for about 25 years used as a sign, and upon their labels, circulars, and prospectuses, the words Pharmacie Centrale de France. The defendants had as their sign the words Pharmacie Rationnelle, but added thereto the words Centrale de France. This fact was recognized by the court as an attempt to create confusion between the two establishments, and the defendants were prohibited from the further use of the latter mentioned words, as was also done in a case between the same plaintiff and Tessier & Co., the year following. In the same court, in 1858, came up the case of Scortos v. Hogg, two Englishmen, cousins German and pharmacists, and former fellow students in the office of one Robert. The plaintiff, as successor in business of Mr. Robert, claimed the designation of London Dispensary, under which his pharmacy was known, and also the title of Pharmacie de l'Ambassade d'Angleterre. The defendant pretended to have certain rights in Robert's pharmacy, and accordingly used similar names and titles at his store in another street from that in which the plaintiff's was situated. When summoned before the court, for encroachment upon the plaintiff's rights in that respect, the defendant disclaimed all right to the said name and title, but subsequently he took the designations of London Dispensary, and of English Embassy Chemist. This was held to be an infringement, and defendant was forbidden to further use those titles to designate his place of business, and condemned to pay 500 francs damages, and the costs. In the same court, in 1859, case of Le Mercier v. Millen, it was shown that Claude Bully had given his name to an aromatic toilet vinegar, of which he had transmitted the recipe to Jean Vincent Bully. The plaintiffs had purchased from the latter his business and the sign of the inventor. The defendant made and sold a toilet vinegar under the name of Bully, with the sign Au Temple de Flore. Judgment for plaintiffs. In the Court of Paris, in 1862, case of Muller v. Compagnie Immobilière, it appeared that the plaintiff had for more than 15 years carried on a hotel known as the Hôtel de la Paix, situate at the angle of the Street de la Paix and the Boulevard of the Capucines. The defendants built a hotel on the same boulevard, and gave it the same name as the plaintiffs. The court below, the Tribunal of Commerce of the Seine, had declined to completely suppress the name thus assumed by the defendants, but accepted their offer to adjoin the word Grand, and ordered that their sign be altered within the period of 2 months, so that, in letters all of the same size, it should read Grand Hôtel de la Paix. On appeal, it was held that the words Hotel de l'Apex were indicative and characteristic of the hotel owned by Muller, and that those words could not be employed by others in the same business without violating his rights. A few weeks later, the same parties were again before the court. Muller complained that, notwithstanding the judgment in his favor, the defendants continued to announce in the newspapers their hotel under the interdicted name, and that the napkins and towels for table and toilet, the bills of fare, and C, of the new hotel were thus marked, and the letters H.P., an abridgment of the sign, were engraved upon the glassware, the bottles, and the plate. The defendants replied that the initials H.P., and even the words Hotel de l'Apex on the linen, all used in the interior of the establishment, could not prejudice the plaintiff, especially the use of the letters H.P., which had no precise sense. They also alleged that the interior arrangements had all been ordered and executed long before the first suit, and argued that the order of the court would not admit of such stringent interpretation as to prevent even the temporary use of the articles mentioned. Held, that the letters H.P. on the porcelain, glass, vessels, silver, cutlery, and divers utensils placed at the disposition of guests, for a purely internal purpose, did not in contemplation of law prejudice the plaintiff. But, although the defendants acted without a fraudulent intent, the use of the words Hotel de l'Apex was a damage to the plaintiff. They were accordingly forbidden to let those words appear on objects either on the exterior or in the interior of their new hotel. But in consideration of all the circumstances, and the hardship that would result from instant suppression, the court granted a delay of 6 months for the removal of the words 66 de l'Apex from the linen and furnishing articles, and allowed the plaintiff his costs. Section 530. Partnership dissolved. Upon a dissolution of partnership, each of the partners has a right, in the absence of a stipulation to the contrary, to use the name and style of a partnership firm. The principles of this case are very plain and simple, and are well settled by authority. The name or style of the firm Banks & Co. was an asset of the partnership, and if the whole concern, and the whole goodwill had been sold, this was a trademark or asset which might have been sold with it. But if the partners chose to divide the partnership assets, each is at liberty to use the trademark just as much as before. Held, that both are entitled to use the style or firm of Banks & Co. Section 531. Representations contained on the blinds and brasses of a shop front, calculated to induce the public to believe that the owner is connected in business with a firm of established reputation, will be considered upon the same principles as govern rights in trademarks. In Glennie v. Smith, it appeared that the defendant had been employed by the plaintiffs for 3 years in their shop, up to April, 1865, and that in May of that year he set up in a like business for himself. The defendant's name, Frank P. Smith, was posted immediately over his shop window, in black letters upon a white ground, while upon the sun blind and brass plate under the window were the words "From Thresher and Glennie," the word "from" being printed diagonally to, and in smaller letters than, the rest. On the part of the plaintiffs, the sun blind and brass plate were produced in court, and photographs of the shop front, from which it appeared that when the sun blind was drawn down the defendant's name was not visible, except to persons passing immediately under the window. They also proved 4 cases in which persons had actually been misled, and to show that the defendant had some misgivings as to the propriety of his conduct, a conversation between him and one of the plaintiff's assistants was given in evidence. The evidence of the defendant consisted of opinions of persons who had inspected his shop, to the effect that the public were not likely to be misled, and of his directions that nothing should be said to purchasers to induce them to think that Messrs. Thresher and Glennie were connected with his business. Section 532. Held, by Kindersley, v.c., the same rule that applies in the case of manufacturers applies also to tradesmen by retail. A man having been in the employment of a firm of reputation, has a right, in setting up in business for himself, in any way in which he thinks fit, subject to the restrictions of the rule laid down in the Leathercloth Company case, and in Perry v. Truefitt, to inform the public that he has been in such employment, and in that way he does appropriate to himself some of the benefit arising from the reputation of his former employers. This makes it the more necessary that he should not act in such a way as to mislead the public to the detriment of his former employers. For the purposes of the plaintiff's right to relief, the intention of the defendant is of no consequence. It is enough if, without any unfair intention, he has done that which is calculated to mislead. Section 533. After commenting upon the nature of the evidence on each side, His Honor continued, that it was in vain for witnesses to say on defendant's part, that, in their opinion, persons could not be misled. When a person goes to try the effect of his own inspection, he knows what he will find, and is prepared to look for the word from. But the general public are off their guard when they pass the shop. But further than this, it is not the question whether the public generally, or even a majority of them, are likely to be misled, but whether the unwary, the heedless, the incautious portion of the public would be likely to be misled. The injunction prayed for was accordingly granted. Section 534. In the Tribunal of Commerce of the Seine, in 1867, Mondin F. Company v. Sariette LS, it appeared that the plaintiffs had adopted as a sign to indicate the nature of their business the words agents des theatres. It was held that another in the same line of business, who had adopted as his sign the words office des theatres, did not infringe upon any right, the words being generic and common. It was no answer that the words might lead to confusion. Section 535. It is unfair competition to indicate by one's sign an industrial product under a name very similar to that of another product, in such manner as to create confusion. In the case of Berthelon y Verge, in the Tribunal Cif. of Lyon, in 1865, it appeared that the plaintiff was the patentee of an invention to which he had given the name of conformateur du tailor. From the name, we may infer that the invention was embodied in an instrument for the shaping of garments to the person. Under this denomination, the machine was indicated in the sign, and in the prospectuses of the plaintiff. The defendant, also a patentee, with the evident intention of causing confusion between his machine and that of the plaintiff, placed upon his sign the words conformateur pour hommes et dames, in characters corresponding with those upon his rival's sign. Per tribunal, this act on the part of Verge does not constitute a counterfeiting or a usurpation of the trademark of the plaintiff, but it is an unlawful competition, and therefore the word conformateur upon the business sign of the defendant must be suppressed, as also upon his circulars and prospectuses. Section 536. As another example of the judicial suppression of fancy names upon a shop sign, we have Treatise v. Fromentel, in the Tribunal of Commerce of the Seine, in 1865. The parties were tobacconists, carrying on business in the same neighborhood. The plaintiff's sign read, La Civet, Civet Cat. He had previously been compelled in defense of his rights to attack a certain Dame Pouce, who had erected a sign reading, A la Civet de la Rue de Rivoli, and had discomfited her by a judgment of suppression, with 200 francs damages and costs. This time it was the Dame Fromentel who thought to avail herself of the reputation of the plaintiff's wares, by putting up a sign reading, A la Nouvelle Civet. As it was plain that her motive was to profit by the justly gained popularity of the establishment of Treatise, a judgment was rendered similar to that in the other case. Section 537. Labels and wrappers. We will now consider another class of cases, which seem to form a connecting link between those where the goodwill of a trade has been protected, and those which may be characterized as relating to trademarks proper. This is where the advantage in the market, or goodwill, is due either to the name of the trader or trading firm, or to his or their place of business, or to both these causes combined, but not being, as a goodwill, allowed to rest merely in nubibus, is embodied in a label or wrapper, and affixed to the article sold. This name becomes then a quasi-trademark. Section 538. Croft v. Day is a very important case under this head. The quasi-trademark that consisted in the name of Day and Martin, and their address, 97 High Holborn, with other devices on a printed label attached to the bottles of blacking made by the plaintiffs, the executors of the former firm of Day and Martin, and then carrying on the same business. This was so closely imitated by the defendant as to afford the fair presumption that he intended the public to be deceived into buying his blacking as and for that of the original firm. The Master of the Rolls, in his judgment, observes that the act complained of was equivalent to a sale by the defendant of his goods as those of the plaintiffs, and that two things were requisite for the accomplishment of this fraud. First, a general resemblance of the forms, words, symbols, and accompaniments, such as to mislead the public. Secondly, a sufficient distinctive individuality was to be preserved, so as to procure for the person himself the benefit of that deception which the general resemblance was calculated to produce. In Coffin v. Brunton, the defendant, in combination with others, fraudulently issued to others a preparation called Ohio liniment, having upon the bottles containing it labels with directions exactly similar to that used by the complainant for his Chinese liniment, and he made representations to induce the public to believe that the composition sold by him contained the same ingredients as the Chinese liniment. Maclean, J., said that from the body of the label and of the directions for the use of the medicine, it was clear that the language of the defendant was so assimilated to that of the plaintiff as to appear to be the same medicine, the alteration being only colorable, and was intended to avail himself of the favorable reputation acquired by the Chinese liniment. An injunction was granted to enjoin the defendant from using the labels or directions accompanying the liniment sold by him, or other labels or directions or advertisements or handbills tending to produce a false impression in the public mind that the liniment sold by him contained the same ingredients as the Chinese liniment. It should be noted that this case is frequently referred to as one of trademarks, but improperly so. The word Chinese was the only symbol capable of exclusive appropriation, and that was not pirated. The Merrimack Company v. Garner case belongs to the label class, in that the plaintiff's label was Merrimack Prints, Fast Colors, Lowell, Mass. And that of the defendant, English Free Trade, Merrimack Style, warranted Fast Colors. The court, in Bank, dissolved an injunction which had been granted its special term, and left the parties to try the issue of an actual imitation involving the question of fraudulent intent and actual injury. So, also, does the case of Dale v. Smithson belong to the label class? The plaintiff affixed to each package of thread sold by him a label, reading as follows: Courtier Flax, Thomas Nelson and Company, warranted, Fast Colors and 16 Oz. What word or symbol is here to constitute an exclusive emblem? Courtier might possibly, if it were a fancy denomination, and not descriptive. The defendants adopted and used in a similar manner upon their thread a label so closely imitating that of the plaintiff as to leave not the slightest doubt of the intention of fraud. The judgment of the judge at special term granting an injunction was, therefore, affirmed at general term. Newman v. Alvord is nothing more than a label case. Both parties used the word Akron, the name of the place where the plaintiff had a manufactory, and the defendants had not. The name Akron, being a mere geographical designation, could not be exclusively appropriated, for the reason that all inhabitants of the place had a perfect right to affix it to their goods. But as there was no room for doubt, in the mind of the court, that the said name was used by the defendants to enable them to avail themselves of the patronage justly belonging to others, an injunction granted its special term was sustained. Falkenberg v. Lucy is a label case, although frequently miscalled a trademark case. Sawyer, C.J., said, "Can there be any doubt that the verbatim copy of the entire label of plaintiff, except the heading, the name of the maker, and place of manufacture, and adopting it as the label of the defendants, was done for the purpose of inducing the public to believe that the defendants was precisely the same thing as, and possessed the identical properties of the compound manufactured and sold by the plaintiff, and for the purpose of availing themselves of the reputation established by the plaintiff? It was sought to protect an elaborate label under a statute of the state of California, including any peculiar name, letters, marks, figures, or other trademark or name, cut, stamped, cast, or engraved upon, or in any manner attached to or connected with any article, on with the covering or wrapping thereof, and c. Comprehensive as is the language of the statute, and palpable as was the imitation of the plaintiff's label, yet the Supreme Court of California held that the label contained no peculiar names, trademarks, and c. in the sense of the statute which the defendants had copied, nor was the plaintiff entitled to any protection of the words in common use in our language which composed the profusely worded label. The injunction granted below was accordingly dissolved. The case of Boardman v. The Meriden Britannia Co.Commonwealth in the Supreme Court of Connecticut, in 1868, is a fair illustration of the protection which courts award to a meal label, which has been fraudulently imitated for the purpose of diverting custom from its legitimate channel. The labels used by the respondents were of the same size and color as the labels of the petitioners, and the same numerals were used for the same class of goods. The petitioner's label read thus: 1 to 2 gross L. Boardman's number 2340 wire strengthened, French tipped teaspoons, and that of the respondents read 1 to 2 gross Meriden brighter. Co.S number 2340 wire strength D, French tipped, oval thread teaspoons. Both parties seem to have regarded the use of the numerals 2340 as giving rise to the most important and most material question in the cause, but Carpenter, J., in delivering the opinion of the court, said that whether in any case numbers alone may be legitimately appropriated as trademarks, was a question not necessarily involved in that case. It is apparent, at a glance, that neither of the labels contained a single essential element of a technical trademark, although the court loosely used that convenient term. From the finding of facts, we can judge for ourselves of the class to which the case belongs. It was found that the respondents manufactured spoons similar in character to those made by the petitioners, though differing somewhat in style and pattern, and prepared labels resembling those of the petitioners, and adopted the same numbers as had been adopted by the petitioners, adapting said numbers to similar kinds of spoons. We can classify the case as one of unfair competition in trade by means of a simulated label. A remedy was due, and the court awarded it. The court said, "Have the petitioners suffered damage?" On this point, there is no room for doubt. The finding of the committee is explicit, that said respondents have sold large quantities of their spoons so put up, in place of spoons manufactured by the petitioners, as alleged in the petition. It is also apparent, from what has already been said, that the petitioners are in danger of still further loss, unless protected by an injunction. The circumstance that the respondents now prefix a cipher to the numbers would hardly vary the result. Their motive is apparent. They may succeed in reaping some advantage from the numbers as thus used, but it is manifest that it will be at the expense of the petitioners. All the judges concurred in giving judgment for the petitioners. Section 539. As to the right of property in the name of another, we have a case in the Court of Besançon, in 1861, Loromia for Bavette v. Du Bois. The house of Bavette, of Fleurier, a village of the canton of Neufchâtel, in Switzerland, manufacturers of watches for exportation, especially to England and China, authorized M. Loromia, a watchmaker at Besançon, in France, to use the name of Bavette as a trademark. Loromia duly deposited the said name as his trademark. By authority of his right to use the same, he seized certain watches, then at the custom house, in transit for China. The tribunal of Pontalia rejected the demand for condemnation. Loromia appealed. The appellate court said, for more than 30 years Loromia has manufactured watches for the Bavette firm. From the beginning of his relation with that firm, he has been authorized to engrave upon the watches made by him the name of Bavette, and, for more than 30 years, he has constantly sold in China watches bearing the mark of Bavette, the same being in Chinese characters. Said mark, considering the relation of the two houses, is as much the property of Loromia as it is of the Bavette house. The defendant has usurped, by his products of an inferior quality, the confidence and the credit attaching to the merchandise of the plaintiffs. If tolerated, there would be no security for commerce. Two owners may use the same mark when their interests are united. The right to the use of the mark of Bavette in the Chinese is in both plaintiffs. Injunction. Damages, 1,000 francs, and costs. Although this is a matter somewhat in the nature of a trademark proper, it should be classed with mere labels, and treated as such. Being the simple name of a manufacturer, It of course could not be treated in any part of the commercial world as the peculiar arbitrary symbol that commerce requires. It serves our purpose as an illustration of the fact that a man may have a qualified right to the use of another's name as a more sign. Section 540. Colton v. Thomas is to the same effect as the foregoing. The complaint charged an improper and fraudulent use of a name or designation of business, placed by the defendant upon cards and in advertisements, and also upon a sign hung out upon the street in front of his dental rooms. The bill alleged that the plaintiff had purchased from Dr. Gardner Q. Colton the right to use the name of the Colton Dental Association in connection with the use of nitrous oxide gas to alleviate pain in extracting teeth, and that he used the same in all his advertisements, and prominently displayed it on his signs, doors, and windows. That the defendant, who had been in his employment, left him, and opened dental rooms in the same street, and issued cards in form following: Dr. F. R. Thomas, formerly operator at the Colton Dental Rooms. Teeth extracted without pain by nitrous oxide gas, and that he had a sign over his door of the same purport. It was alleged that the words formerly operator at the upon the cards and sign were in small letters, illegible except to one nearby, while the words Colton Dental Rooms were in large, bold type and letters, so as to be seen at a great distance. The plaintiff's right to use the name was not denied, nor did the defendant set up any corresponding right in himself. His defense was, that he employed the words Colton Dental Rooms without any intention of defrauding the plaintiff, and that his sole object was to protect his reputation, and secure to himself the full advantage of it by advertising the fact that he had ceased to be the operator at the rooms of the plaintiff, which he claimed to be a perfectly fair and legitimate purpose. From the opinion of Allison, P.J., we learn that the signs which hung over the doors of the plaintiff's rooms, number 737 Walnut Street, and over the defendant's at number 1027 of the same street, were in size, shape, and general appearance very like to one another. The material portions of the lettering required a careful inspection to notice any difference between them. They both hung in the same manner, on the same side of the street, and might readily be mistaken the one for the other, especially by suffering patients impatient for relief. The same might, to some extent, be said of the cards. An injunction was granted against the use of the cards and sign, and the employment of any device by which the patients and patrons of the plaintiff, without the exercise of excessive care, would be induced to suppose that the defendant's place of business was the place of business of the Colton Dental Association. Section 541. The Dissolution Crucible Company v. Guggenheim is purely a label case, and it need hardly be referred to in this place, further than to invite attention to the fact that the protection claimed was embraced in a statute of the state of Pennsylvania, for the protection of private stamps, wrappers, all labels. The defendant was enjoined against the use of the name of Dixon, to which he had no right or title. It was not pretended that this was a case of a common law trademark. In Blowfield v. Payne, a law case, the declaration stated that the defendants wrongfully, and without the consent of the plaintiff, caused a quantity of metallic hones to be made and wrapped in envelopes resembling those of the plaintiff, and containing the same words, thereby denoting that they were of his manufacture. On trial before Denman, C.J., it appeared that the defendants had obtained some of the plaintiff's wrappers, and used them as alleged. It was held by the court in bank that as the defendants had used the plaintiff's envelope, and pretended it was their own, the plaintiff was entitled to recover some damages. In Holloway v. Holloway, the defendant sold pills and ointment with labels and wrappers copied from those of the plaintiff. The master of the rolls pronounced the act to be as clear and as plainly avowed a fraud as he ever knew, and granted protection accordingly. In Edelston v. Vick, the defendant used labels in palpable imitation of the plaintiff's, and was restrained. Section 542. A source was invented many years ago by James Cox, of Reading, and named by him Reading Source, under which name it acquired considerable reputation. The success of the manufacture induced others to make and sell what they called Reading Source, and in order to distinguish the article manufactured by James Cox and his successor in business, he and they had for many years been in the habit of wrapping the bottles of sauce, the labels of which always had the original Reading Source. The plaintiff's label was imitated in part, but plaintiff admitted the only thing to which objection could be taken was the use of the words, the original, the labels being otherwise distinguishable. Section 543. The defendant by answer alleged that the sauce manufactured by him was made from an original recipe to which the plaintiff had no title, and submitted that his sauce deserved the title of original as much as that of the plaintiff, and he further alleged that the plaintiff's was known to the trade as Koch's reading sauce, and not as the original reading sauce. Evidence in support of the last mentioned allegation was given in his behalf, while, on behalf of the plaintiff, two of the partners in the firm of Cross and Blackwell, pickle manufacturers in London, deposed that the use of the word original as part of the title or description of a sauce such as reading sauce, would lead those in the trade, and the public, to conclude that the sauce so described was the manufacture of James Cox or his successor. There was no evidence that anyone had been misled by the words on defendants' wrappers. Lord Romilly, M.R., said, among other matter, the question, then, is this: there being abundant evidence to show that there are a great number of persons who make reading sauce, whether the person who is the owner of the original recipe which gave the name, and from which the article called reading sauce acquired its character, is not entitled to say, I hold under the original inventor, and the word original means that and nothing else. He said that the use of the word by the defendant was calculated to deceive. The defendant was accordingly enjoined. Section 544. Labels and cautions composed of words in common use in our language cannot be exclusively appropriated as trademarks. But those labels and cautions, although not protected by any virtue of their own, become powerful auxiliaries, bringing punishment upon the wrongdoer. Take the case of Gillett v. Estabrook. The selection of boxes, sizes, colors, labels, cautions, and style of lettering, however innocent it may have been under ordinary circumstances, became the most conclusive evidence of the intent to mislead the public, and to commit a fraud upon the plaintiff in relation to his trademark, yet merely because all those things can be brought forward as witnesses to complete a chain of testimony of guilt. The mere label does not rise to the dignity of a trademark proper. Section 515. When a man has learned a trade secret from his employer, and practiced it after his employer's death, selling the article under the old name, he will not acquire such a right to the exclusive use of the name as a trademark as will be protected in a court of equity. Section 546. The original inventor of a new manufacture, and persons claiming under him, are alone entitled to designate such manufacture as the original, and if he or they have been in the habit of so designating their manufacture, an injunction will be granted to restrain another manufacturer from applying the designation original to his goods. This was the ruling of the Master of the Rolls, in Cox v. Chandler. This case must be classed with cases of unfair competition in business rather than with those of trademarks proper. Section 517. Title of a book. There are cases in which the use of a particular title or title page to a book, or the use of an author's name, has been restrained by injunction. The title of a book or of a newspaper may possess all the characteristics of a trademark, when the same is a newly coined term, or an arbitrary symbol, but that is generally not so. Section 518. In Hong v. Kirby, the plaintiff was proprietor of a monthly magazine published by the defendant, and sold at his shop upon commission. The publication continued during 5 months, but at the end of that time disputes arose between the parties. It was agreed to discontinue the joint publication, and a final settlement of accounts was had. The plaintiff then circulated advertisements, stating that the publication under its old title would be continued by him, and that a 6th number of the magazine would be, as it accordingly was, soon afterwards published by him. The defendant at once advertised and published the first number of a periodical work under a title similar to the plaintiff's, but described as a new series, improved. An injunction was applied for, to restrain him from selling any copies of his publication, and from printing or publishing any future or other number, either under the same or any similar appellation, and from borrowing and using the appellation, or copying the ornaments, or any part of the plaintiff's original publication. Several circumstances were alleged by the bill to show that the defendant's work was intended to mislead the public to the conclusion that it was a continuation of the plaintiff's, such as the general resemblance, though not an exact similarity of its title page or wrapper, the continuation in the new magazine of an article left unfinished by the old, and the publication of an index to the first 5 numbers of the old work, under the name of an index to the first part. This intention was, however, denied by the answer, which attempted to give a sufficient reason for the steps taken in composing the form and substance of the new magazine, to show that it was not intended to represent it to the public as a continuation of the old work, and the defendant submitted that he had a right to publish a work under a similar title. The court held that, upon the facts stated, there appeared to be an intention on the part of the defendant to put his work before the world as a continuation of the old magazine. Lord Eldon, in that case, did not rest his decision so much on the ground of copyright, or of contract, as upon that of fraud. He stated the question to be, not whether the work was the same as the original, but whether the defendant had not represented it to be the same, and whether the injury to the complainant was not as great, and the loss accruing to be regarded upon the same principles between them, as if it were, in fact, the same work. What we may gather from this decision amounts to this, that, by a certain resemblance of form and matter, a publisher may not with impunity put forth to the public a literary work to be taken for another work of an established reputation, and thus fraudulently reap the advantage enjoyed by the original work, and that this advantage in the market corresponds in some measure with the property created by the Copyright Act, and is protected on analogous grounds. Section 549. A case of a similar character is that of Spottiswoode v. Clark. There the plaintiff was the owner of a publication called the Pictorial Almanac, for 1847. And the defendant of one called Old Moore's Family Pictorial Almanac. The plaintiff alleged that the defendant's work was a piracy on his publication, and filed a bill for an injunction. With regard to the substance and internal portion of the two works, there was little or no resemblance, but the covers were, to a certain extent, similar, both being decorated with a pictorial representation of the observatory at Greenwich, and in the title, as printed on the cover, making use of nearly the same expressions. The bill alleged that this imitation was intentional, and done with a view to deceive the public, to the injury of the plaintiff. The Lord Chancellor said, among other things, in the course of argument, cases of trademarks were referred to, but trademarks have nothing to do with this case. Take a piece of steel. The mark of the manufacturer from whom it comes is the only indication to the eye of the customer of the quality of the article. So it is of blacking, or any other article of manufacture, the particular quality of which is not discernible by the eye. In the present case, if anybody is deceived, it is not by the eye, for anything more different than the two articles in question can hardly be conceived. Both covers represent a portion of Greenwich Observatory, and profess the work to be for all sorts of persons. It is difficult to believe that all this is accidental, but if it is a fraud, it is the most clumsy fraud that I ever saw, for it could deceive no one. He accordingly dissolved the injunction granted below, the defendant undertaking to keep an account, with liberty to the plaintiff to bring an action. The whole gist of the matter lies in this: if no one could be deceived, the plaintiff suffered no injury, but if a casual observer would probably be misled, then the principle laid down in trademark cases would be applicable, and the use of a particular name, title, or wrapper, would be restrained. This case has been cited and followed. Section 550. In Snowden v. Noah, the complainant had purchased from the defendant the right to publish at the City of New York a newspaper called the National Advocate. The defendant subsequently published at said city the New York National Advocate. Sandford, ch. held that there was such a difference as to warrant the court in refusing an injunction to restrain the defendant. So, in Bell v. Locke, Walworth, ch. denied an injunction to restrain the defendant from publishing or circulating a newspaper called The New Era, which was alleged to be an infringement of the rights of the plaintiff, who published the Democratic Republican New Era. Besides the difference in titles, the defendant's paper, upon its face, purported to be a revival of an old paper, in which he was formerly interested with the complainant, which paper had been voluntarily discontinued by both for more than 18 months. In Matsell v. Flanagan, the complaint alleged that the plaintiffs were, and long had been, the publishers and proprietors of the National Police Gazette, which was commonly known to the public as the Police Gazette, and it appeared that it was the only police gazette, eo nomine, published in the United States, at the time of the publication of this paper. It further appeared that the defendants were engaged in publishing and selling a paper called the United States Police Gazette, which, from its general character and appearance, was a fraudulent simulation of the plaintiff's paper. The words Police Gazette, forming a part of the title, were printed in type similar in character to that employed by the plaintiffs for their print, and a similar imitation characterized the general form, style, type, and device of the paper complained of. It was shown that the public were actually misled into purchasing the defendant's paper for that of the plaintiffs, and the more easily as when the United States Police Gazette was folded, and lying upon the newspaper stands, as is usual and customary. The words United States, which made the difference between the titles of the two papers, would be concealed. The manifest fraud in this case distinguishes it in principle from Snowden v. Noah and Bell v. Locke, supra. The injunction was continued. In Stevens v. DeCanto, the main question was, whether the name of a newspaper in the Spanish language, called El Cronista, published by the defendant, was an infringement upon the name La Cronica. Monell, J., held that there was so manifest a dissimilarity in the general appearance of the two titles, both as respects the formation of the words and the character of the type employed in printing, that no Spaniard could be mistaken. But the case was relieved of all difficulty, as it appeared that the publication of La Cronica had ceased. The injunction was dissolved, and the complaint dismissed. In Dayton v. Wilkes, the goodwill of a newspaper, that is, the celebrity which it had acquired under the name of Porter's Spirit of the Times, was fully recognized a valuable property. And in Clement v. Maddock, where an injunction was granted to restrain the defendant from using the name Bell's Life for his newspaper, the court characterized the suit as an application to support a right to property. Section 551. In the Court of Paris, in 1858, case of Estible v. Petitmang, an appeal from a judgment forbidding the defendant from using the name of a journal, the chair ivory, on card covers for the same, to be used in coffee houses, lecture rooms, and c. It was held that such use did not constitute a case of illicit competition or infringement. The appellate court said that the gilt advertising cards of the defendant were but covers for the chair ivory, which could not create confusion in the public mind with the paper itself, and although, in enclosing the chair ivory in the covers the defendant addressed the readers of the journal, that fact in itself did not make him responsible in damages. The defendant offered to alter this cards so that they should read, cover for the chair ivory, which the court thereupon directed should be done. Section 552. In the Tribunal of the Seine, in 1855, Castor v. Dennery, it appeared that the plaintiff had published, in 1847, a romance, entitled Les Oiseaux de Proie, The Birds of Prey. The defendant brought out a drama under the same title, which was thought by Mr. Castor to be an infringement upon the name he had selected. Held, considering that for a long time the words Oiseaux de Proie have been metaphorically employed to designate certain men, that those men offer types so varied that they are the objects of observations, of studies, and diverse paintings, to each of which the said words are as applicable as to a romance by Castor, and that there is no invention in the title, the demand of the plaintiff must be refused. Section 553. An author or a publisher has, either in the title of his work, or in the application of his name to that work, or in the particular external marks which distinguish it, just such a species of property as a trader has in his trademark. He may, therefore, equally claim the protection of a court of equity against such a use, or such an imitation of that name or mark as is likely, in the opinion of the court, to be a cause of damage to him in respect of that property. Upon this principle rests the case of Thunot du Voten v. de Gorscadot, in the Court of Paris, in 1869. Madame Micord, widow of the historian of the Crusades, had married M. Thunot du Voten, and conjointly with him and others in interest had brought suit to prevent the further publication of a history of the Crusades, which had been brought out by the defendant. The defendant had, in 1868, by means of circulars and notices, profusely scattered about, announced for sale the Histoire populaire nationale des Croisades, by my cord. 4 numbers of this book were published. Having been duly warned by process to cease the publication, he had recourse to subterfuge to give to the complainants a seeming satisfaction. In the 5th number, he ceased to edit the text of the History of the Crusades, by my cord, and substituted therefore the Jerusalem Delivered, of Tasso. The substitution deceived a portion of the public, who believed that the Jerusalem Delivered was a legend of the History of the Crusades, which latter title continued to figure at the head of each page. These combinations and maneuvers constituted a manifest fraud. The Tribunal of Commerce of the Seine, which had original cognizance of the case, held that it had jurisdiction of the matter as a commercial act, the parties appearing in the character of merchants. Judgment for complainants. Upon appeal, the defendant invoked his good faith to repel the presumption of tort. He fared no better than in the forum below. The court said, inter alia, considering that my cord is a contemporary author, that his History of the Crusades has a merit and renown that the defendant was among the first to recognize, that the defendant is a bookseller and editor in Paris, where divers editions of this book have been published, that under these circumstances he cannot pretend ignorance of the fact that the name has not become public property, but belongs to the heir and assignees, or, if he had a doubt thereon, the most simple effort would have dissipated the doubt, that he cannot pretend that he prepared and commenced the publication in good faith, but has manifested his bad faith by his acts. Therefore he is guilty of counterfeiting, and the judgment must be affirmed, with costs. Section 554. In the remarkable case of Lord Byron v. Johnston, the defendant, a publisher, advertised for sale certain poems, which he represented by the advertisement to be the work of Lord Byron, on whose behalf a bill was, during his lordship's absence abroad, filed to restrain the publication under the title described in the advertisement. There appears to have been some doubt at the time of the original publication whether or not the poems were Lord Byron's, but when the defendant, at the hearing, declined to swear as to his belief that the poems in question were actually the work of Lord Byron, the court granted the motion for an injunction until answer or further order. This seems like recognizing a proprietary right in a mere name. At least, it goes so far as to grant relief against damage arising from the use of a particular name in conjunction with a particular article offered for sale, it being impossible for the purchaser to ascertain, on mere inspection, the truth or falsehood of the representation on the faith of which he buys the article. Section 555. It is difficult to reconcile the principle of the decision in this case with that of the decision in Clark v. Freeman, where the eminent physician, Sir James Clark, applied for an injunction to restrain a chemist from publishing and selling a quack medicine under the name of Sir James Clark's consumption pills, but the court refused to interfere, because it did not appear that Sir James Clark had sustained any pecuniary injury. The only distinction between the principles of the two cases seems to be this, that in the former the author must be held to have a species of property in his name, consisting in the recommendation to the public which the use of that name gives to the sale of a literary work, while it did not appear that Sir James Clark was in the habit of selling medicines, or of deriving a profit from the sale of medicines, and therefore it could not be argued that he had suffered injury in trade, and the court could not recognize an injury done to his reputation, which it treated as an illusory damage. It must, therefore, have held in the former case that the author has a species of interest in his name quite similar to that of a trader in his mark affixed to the articles manufactured by him. Section 556. Yet there does seem to be natural justice in protecting one's name from contempt or unpleasant notoriety, which may amount to infamy. Could not the eminent physician have been seriously damaged in his practice by the usurpation of his name by a quack? And was he not in all probability injured in his professional reputation by the conduct complained of? If this decision is sound, may not any man's name be blasted by the brazen villainy of another who chooses to borrow his name? In France, a different doctrine is maintained, as is evident by the judgment of the Tribunal Sif of the Seine, in 1869, Charles de Bussy v. Charles Markall. The defendant, well known in the literary world under the pseudonym of Charles de Bussy, is the author of numerous publications which have appeared under the assumed name. Among them is a brochure entitled L'Impiste Figaro, and another entitled Le Cas de M. Rochefort. The plaintiff, an engineer of Paris, who aspired neither to immodest notoriety nor the imputation of embroiling himself in political affairs, obtained an injunction against the further misuse of his name, with 50 francs damages, and costs. Section 557. The name of a song. Certain music publishers having adapted original words to an old American air, which was rearranged for them, gave to the song so composed the name of Minnie, and procured it to be sung by Madame Anne Hilden, a popular singer, at M. Julian's concerts in London, and when it had by that means become a favourite song, they published it with a title page containing a picture of the singer who had brought the song into notice, the name Minnie, and C. held, that the publishers had by these means obtained a right of property in that name and description of their song, which a court of equity would restrain any person from infringing. Another party infringed upon the same by using the words Minnie, dear Minnie, and was restrained by an interlocutory injunction, without imposing upon the parties the necessity of trying the right at law. Section 558. Printed publications have sometimes their titles registered as trademarks, and they may legitimately be so, provided they have such a distinctive individuality as shall preclude the probability of confusion with the titles of other publications. Our Society and Insurance Monitor seem to be free from any such objection, as applied to periodicals. Section 559. The right to exclusive use must be definite, to entitle the claimant to relief. In England, it has been held that a newspaper is not within the Copyright Act, 5 and 6 Vict. C. 45, and therefore acquires no registration under that Act, but the proprietor of a newspaper has, without registration, such a property in all its contents as will entitle him to sue in respect of a piracy. But there must be something definite and certain in the thing sought to be protected. When the proprietor of a newspaper sought to restrain the piracy of a list of hounds, the court was of opinion, that although the piracy might be established, the list was liable to such frequent changes, and a correct list was so easily obtained, that it was not a case for an interlocutory injunction. Section 560. Names on coaches. A court of equity will restrain a defendant from fraudulently using the same words and devices on an omnibus that the complainant may have previously appropriated to designate his. In Not v. Morgan, in 1836, in the Rolls Court of England, the defendant was restrained from using upon an omnibus the names London Conveyance, and London Conveyance Company, or either of such names, or any colourable imitation of them, or either of them, painted, stamped, printed, or written thereon, or in any manner affixed thereto. Stone v. Garland, in 1850, is a similar case, the defendants having been restrained from improperly using the names Irving Hotel, Irving House, or Irving, upon coaches, and upon certain badges worn by the defendants upon their arms and hats. Section 561. An action of trespass on the case may be maintained under similar circumstances. Thus, in Marsh v. Billings, where the plaintiffs claimed and established the exclusive right to use the name of a hotel, Riviere House, upon coaches, to indicate the fact that they had the countenance of the lessee of that house for the purpose of transporting passengers to and from that house from the railroads. For this privilege they paid an equivalent in the obligations into which they entered. The ground of action against the defendants was not that they carried passengers to the Riviere House, or that they had the words Riviere House on the coaches and on the caps of the drivers merely, but that they falsely and fraudulently held themselves out as being in the employment, or as having the patronage and confidence of the lessee of the Riviere House, in violation of the rights of the plaintiffs. The Supreme Court of Massachusetts held, on appeal in this case, that the plaintiffs would be entitled to such damages as the jury, upon the whole evidence, should be satisfied they had sustained, and that the damage should not be confined to the loss of such passengers as the plaintiffs could prove had actually been diverted from their coaches to those of the defendants. but that the jury would be justified in making such inferences as to the loss of passengers and injury sustained by the plaintiffs as they might think were warranted by the whole evidence in the case. Section 562. Secret process. Breach of faith. There are also cases involving a breach of trust, in disclosing a secret process, a knowledge of which has been gained through confidential relations of the parties. The earliest of these cases, Newbury v. James, shows the difficulties that have been felt in dealing with questions of this sort. The plaintiff claimed to be entitled, under the provisions of certain agreements entered into by the ancestors of himself and the defendants, respectively, to the exclusive right of selling certain powders and pills, well known as James powders, and analeptic pills, as agent to the defendants, and prayed a decree for specific performance of agreements. The pills and powders were made up by the defendants from an alleged secret recipe, and it was sought to restrain them from communicating this recipe to any other person without the plaintiff's permission. The court does not seem to have looked upon this secret recipe in the light of property, the subject of certain agreements as to the manner of enjoyment, and as clearly liable to injury from divulgation. Had this been done, there probably would not have been serious difficulty in framing an injunction in restraint of such a contemplated injury, even though the court might not have been able to decree the specific performance of the agreement. On this head, the Lord Chancellor said that either it was a secret, or not. If a secret, what means did the court possess for enforcing its own orders? If not a secret, there was no ground for interfering. If the art and method of preparing the analeptic pills, for which no patent had been procured, were a secret, what signified an injunction? The court possessing no means of determining on any occasion whether it had or had not been violated. The only way in which a specific performance could be effected would be by a perpetual injunction, but this would be of no avail unless a disclosure were made to enable the court to ascertain whether it was or was not infringed. And in complaining of a breach of an injunction, it would be necessary first to show that the injunction had been violated. The injunction was therefore dissolved. In Williams v. Williams, it was said that the court would not struggle to protect secrets in medicine of that sort, but that it was different in the case of a patent, because the patentee was a purchaser from the public, and bound to communicate his secret at the expiration of the patent. This point has been settled with tolerable distinctness in Dietrichson v. Caburn. Lord Cottenham virtually decided that, where there is such an infirmity in an agreement that it cannot be performed in all its parts, the court will not by injunction compel a defendant to perform the one part, it being at the same time unable to compel the plaintiff to perform reciprocally the other, namely, that which was positive in the agreement, if its age should be appealed to by the defendant in order to procure for him the benefit of the contract or agreement. We find, however, that in Wattle v. Wynyard, the defendant, who had been employed as the plaintiff's assistant under an agreement by which he was to have a salary, and be instructed in the general knowledge of the business, but not in the secret of manufacturing the medicines sold, was restrained from divulging those recipes to which he had surreptitiously gained access, and from making up and selling the medicines compounded from the recipes, with certain printed instructions, almost literally copied from the plaintiffs. In this case, the decree proceeded on the ground of trust. So, also, in Green v. Folgham, where the defendant was held to be the trustee of the secret of compounding the gold ointment, under the trusts of a certain settlement, and was ordered to account for certain mezen profits made by him in the sale of the ointment, the court even going so far as to direct the valuation of the secret to be made for the purpose of administering the trust property. In Tipping v. Clark, a case arising out of a dispute between two merchants, in the course of which the defendant, in a letter to the plaintiff, stated that he had acquired a knowledge of his books and accounts, and that he intended to make a public exhibition of them, we have a recognition of the same doctrines. In Morrison v. Moat, it appeared that the plaintiff and the defendant had for some years carried on in partnership the business of making and selling Morrison's Universal Medicine. On the dissolution of the partnership, the defendant, who had retired, set up for himself, and made and sold the original medicine under its former name as prepared by him. It appears that the plaintiff, in praying for an injunction, did not omit to put forward the ground of fraud or misuse of his labels and trademarks by the defendant, but he relied on this only in aid of the principal head, that of breach of faith and contract, and it is on this ground that the decision rests. In France, the law recognizes the secrets of manufacturers as property, and Article 418 of the Penal Code severely punishes clerks or workmen who divulge the secrets of manufacture of their employers. Section 563. On the other hand, where no charge of breach of trust is involved, courts will not protect the proprietors of secret medicines or other compounds not patented, and anyone possessing himself of another's secret by fair means, may make and vend the same, provided he sell it as his own manufacture, and not that of a party complaining. Thus, in Davis v. Kendall, where the plaintiff had no patent, and therefore 110 exclusive property in a medical compound invented and sold by him, and known as the painkiller, the court said that all were entitled to make and vend the compound. The same doctrine was recognized in Comstock v. White. The defendants in that case, after dissolving their connection with the plaintiffs as partners, commenced using the name or designation of Dr. Morse's Indian root pills, to which neither party had any exclusive right without a patent from the government. The court held that while an injunction should not be granted against an innocent defendant, yet where it appeared that the defendants, in having connected themselves with the plaintiff in selling the medicine by a particular name or designation, and having induced the plaintiffs to expend large sums of money in advertising, and see the medicine manufactured, and then suddenly and without notice, in an unjustifiable manner and apparently from improper motives, severed their connection with the plaintiff and set up the same business for themselves, an injunction should be granted. Section 564. As an instance of reparation for a wrong done, we will take a case tried in the Court of Paris, in 1861, Galley v. Maucayan F. Co. Galley was the inventor of certain pharmaceutical products, which he sold under the denominations of syrup iodidrique, iodidrate de fer, of bonbons iodidriques, and of pate pectoral de réglisse iodidrique. He made the defendants the exclusive agents for the sale of his said products, upon the condition that they should use upon flasks, boxes, and prospectuses the above-mentioned names, and also the name of Galley, as inventor. They omitted his name, wherefore he sued. The court took into consideration the publicity which the defendants had given to the spurious labels, and said that, as the defendants had committed the wrong by means of announcements made by the Société Hydrophile, in the journals Le Cycle, La Presse, Les Débats, La Patrie, La Constitutionnelle, La Pays, and in the journal called La France Médicale et Pharmaceutique, it was just that the order of the court should receive the same publicity at the expense of the defendants. In addition to costs, and c. the publication was ordered to be made showing the judgment for the plaintiff,